Welcome to our webinar on managing COVID. And here we are in the fall of 21. Again, this is in reflection to the provincial health order issued September 10th, 21 in relationship to gatherings and masks, and if, how, and whether they may or may not apply to residential strata corporations and meetings. Alison Baker and Andrea Rasso from Clark Wilson are online, and they're going to walk us through this. There are, from our perspective, as I'm sure as well as yours and everyone who is having to deal with this, almost more questions than there are answers in a number of ways. So hopefully Alison and Andrea are going to kind of get us through some of the mud as we go through this. Our sponsor this week is Remdale Painting and Restoration, and Dan and his team, thanks so much for all of the great support work that you provide us. It's always a real pleasure working with you guys. Just a little bit of a privacy note: don't ask any questions. Please use the Q&A. I will monitor it, and we'll try to come back to each of your questions, or at least bundle them in by topic. But don't put any personal information within your questions. You are essentially anonymous as it is right now. And none of the advice given is legal advice, specifically because the speakers do not have the opportunity to be disclosed very specific details, documents, or because of the confidentiality of the nature. The other thing that is very important is this is a time-sensitive session. We could have a change of information or orders any day, any week, any month. So monitor closely, and as I do have updates, we will host additional sessions and try to provide you with additional information. From a best practice or the most reasonable method of administering meetings and administering use of property, we're preparing some checklists based on the structure of the guidelines that have been put out with the orders, and we'll post those to the COVID bar on the CHOA website in the next few days as well. So Alison, thanks so much. I'm going to sit back and see if you can unmuddle the greatest muddle of ever in some ways. So it's all over to you.
Okay, thanks everyone. Thanks Tony, and hi everyone. I'm Alison Baker. For those of you who don't know me, I'm a lawyer at Clark Wilson who primarily practices in strata law. I've got with me as well my colleague Andrea Rasso, who is the chair of our labor and employment group. And I've wrangled her into this because a number of the issues and questions that come up in strata matters related to COVID relate to strata employees and independent contractors who are interacting with the strata corporation. So thanks very much, Andrea. So as a starting point, as Tony mentioned, we're sort of the framework for this is the provincial health order that was issued on September 10th. There's actually a second health order that has potentially some bearing on strata corporations, which is the September 2nd one. So to be clear, the September 2nd order relates to masks. The September 10th order relates to gatherings and events, and is the one that has the proof of vaccination wording in it. As you will see, however, the orders are not the end of issues for the strata corporation or the source of obligations for the strata corporation. At the end of the day, I think strata corporations are going to have to come back to their basic duty of care to manage the common property for the residents of the building and other people who come into contact with the strata corporation. So that's Section 3 of the Strata Property Act. Also, other pieces of legislation that can come into play when you're dealing with COVID and strata corporations would be the BC Human Rights Code and the BC Personal Information and Protection of Privacy Act, what we call PIPA. And I didn't mention it here, but I'd also say WorkSafe BC related legislation can also have an impact when you're dealing with employees of the strata corporation and potentially independent contractors. So missed that one, apologize, Andrea. So as Tony mentioned, the focus of this session is really going to be on the residential strata corporations. Obviously, there's lots of different kinds of strata corporations out there. In some ways, the commercial ones are a little easier to deal with because the orders are actually directed much more towards a commercial setting than they are to a residential setting, and in particular a residential strata setting. So Tony, if we could move on to the next slide. So as I mentioned, the strata corporation has a duty to manage the common property. And as part of that duty, it has to look towards protecting the health and safety of residents, employees, and visitors while on the common property. And that's going to require some planning on the part of strata councils and on the part of property managers. And that can be either formally or informally developed into plans. Ideally, it would be somewhat formally, as in the council develops a plan or multiple plans, because your strata is going to have different aspects to the strata corporation, such as potentially the typical common areas, such as lobbies, hallways, elevators, that kind of thing. But there may be other expanded areas, such as gym facilities, pools, amenity buildings. As well, there'll be different circumstances or situations or events that the Strata Corporation has to take into account, particularly things like the general meetings of the Strata Corporation, but also council meetings. And then finally, we are going to touch on the orders today, and they do contain some mandatory requirements that are imposed on strata corporations, and as well there'll be potentially provisions from WorkSafe BC related legislation or protocols, that policies that have been developed by WorkSafe BC that may apply. But at the end of the day, I think the takeaway should be that strata corporations have to look at what is reasonably prudent to manage the risk of COVID in the circumstances, and don't necessarily dwell so much on the wording of the orders. Quite frankly, sometimes the wordings of the orders can they're not drafted for strata corporations. So if you focus too much on the order, you might lose some of the good recommendations that can be taken away from the orders, even where they don't directly apply to a strata corporation. So the first question that we often get asked, or one of the many questions we often get asked, are masks required to be worn within residential strata corporations? So the first thing to do is to look at the provincial health orders themselves. So the first one, as I mentioned, is the mask order. That's the September 2nd order. And the provisions of that order state that they apply to visitors, which is a defined term, and indoor public spaces, which is also a defined term. Now, visitors excludes operators, and operators also includes owners. So for the most part, there are some specific circumstances where operators are required to comply with the terms of the mask order, but they wouldn't apply in a residential strata situation. So what we can end up with is a sort of an anomalous situation where owners are may not be required to comply with the mask order, but tenants, occupants, and other visitors might. So we then look at the definition of indoor public spaces, and as drafted, it doesn't appear to include strata corporations based on the wording. What it talks about is buildings and structures that are used for certain purposes. And the purposes do not include the typical residential strata corporation setting. What they do include, however, is fitness facilities, entertainment or recreational facilities, conference centers, or community halls. And all of those would appear to capture areas of strata corporations that have amenity features to the complex. So in short, the order appears to capture tenants, occupants, and visitors who are using fitness facilities, entertainment facilities, conference facilities, or community halls. Well, that ends up with this rather bizarre situation where some people are wearing masks and some aren't, and you've then got to check who fits into what category. So I think masks are definitely one of those situations where you fall back on what is the strata corporation's duty to manage common property and what is reasonably prudent as a measure to deal with the potential spread of the virus while on common property. And that then leads to the strata corporation's ability to adopt rules or bylaws that can mandate that residents and visitors wear masks on common property. that then leads to the question, what happens with employees? So Andrea, I'll turn it to you to talk about the issue of employees and mask wearing.
Thanks, Allison. So thanks everyone for joining us today. I'm happy to be here. So if somebody were to ask an employment lawyer about a year and a half ago whether or not they could mandate mask wearing in the workplace, I think every employment lawyer would have laughed at you. But here we are in 2021 where wearing a mask has become somewhat commonplace and everyone is used to it. So there is nothing that prevents an employer at this stage from requiring the use of masks. The employer can do so by way of policy, and I think the vast majority of employers are continuing to mandate those masks. Of course, and I think Allison will get to this further, we do have the human rights legislation that always has to come into consideration because it pretty much overrides every other legislation or any policy you can come up with. And so if somebody has a reason why they cannot wear a mask, based on one of the protected grounds, then you have an obligation to accommodate that. So really the one that will come up is either a physical or a mental disability. So there are certain individuals who cannot wear masks for physical reasons. And there are some individuals with mental disabilities. For example, I had a situation involving an employee with Asperger's, and wearing a mask caused panic attacks and interfered with their cognitive ability, making them unable to work. So where you have those situations, you are going to have to accommodate up to the point of undue hardship. And so accommodation measures, we'll talk about this a little bit later, but they can be doing things like rapid testing or other protocols that you have in place, you can beef up. So that is always something to keep in mind, but as a general proposition, yes, you can continue to mandate mask use in the workplace.
Thanks, Andrea. So the comments that Andrea just made about mask wearing and how it applies to employees and the fact that you have to take into account potential obligation to accommodate under the BC Human Rights Code would equally apply to residents and visitors who are required to wear a mask pursuant to a bylaw or a rule. The Strata Corporation may receive requests for accommodation in the form of dispensation from that particular mask or rule, and the Strata Corporation would have to take that into account at the time that accommodation request is received. So I think the bigger one that's coming up now, because we've been dealing with masks for such a long time, is the proof of vaccination, particularly now that as of yesterday, we actually, for many locations, we now have to show our proof of vaccination by way of our QR code on our phone or whatever other device that we may have. So under the September 10th order, part of that order deals with the conduct of events, and I'm going to talk a bit sort of gatherings where people are meeting together and sitting down, and I'm going to talk about those in a minute. But probably the more immediate one is the proof of vaccination, and is that a requirement under the September 10th order in respect of Strata Corporation? So the proof of vaccination provisions apply to events in, quote, inside places. Now, both inside place and events have specific definitions, and interestingly, events is not always defined in the same way within the context of the September 10th order. So it's important to look at the order when you're looking at the wording to decide the part of the order that you're referring to in order to decide which definition applies. Similarly, place doesn't have the same definition under the September 10th order that it does under the September 2nd order, which is of course leading to one of the reasons why these orders are so challenging to interpret, because they don't all apply in the same way. So a place is defined as a venue other than a private residence and includes a conference room, recreation center, workout, gym, exercise or dance facility or studio. Now it does have a number of other places, but those are the ones that would be most relevant to a Strata Corporation. And then an event is defined for the purposes of the proof of vaccine requirements as a gathering of more than 50 participants for specified purposes, which include recreational or business, or two, participants gathering for the purpose of an adult sports activity or exercise, fitness, dance activity or class. Now, note with respect to part two, the exercise related one, there is no minimum number of people. So in theory, it could apply to two people gathering together for a sports activity or exercise activity or a class. So that's something to bear in mind in terms of the way this particular order is drafted, is that the provisions don't always apply equally to the size of gatherings. So Tony, could you flip the next slide? So with the proof of vaccination requirements being so limited in the Strata context, at least based on the wording of the order, the next question becomes, can a Strata decide to go ahead and impose a vaccination proof requirement under the Strata Property Act duty to manage common property? Obviously, this is a new phenomenon, so we do not have any case law. Certainly, I would recommend against trying to adopt a proof of vaccination requirement for areas that are essential for residents to access. Things like the hallways, the lobbies, the elevators, the mail, the parkade, access to their strata lots, the strata lots themselves, and the balconies and patios that may be associated with that. The Strata Corporation, I think, would be very challenging to try to to substantiate or justify an order that effectively bans, or sorry, a bylaw or rule that effectively bans somebody from their own apartment or their own house. It just doesn't seem workable. It may be possible for other areas of the common property, such as recreational facilities and other amenity areas, that one would not consider essential to being able to live in their complex. But then, of course, as soon as the Strata Corporation looks at adopting a bylaw or a rule that imposes this kind of requirement, we're then going to get into two areas that are going to create challenges for Strata corporations. One is the BC Human Rights Code, and again, the duty to accommodate. The Strata Corporation may receive requests for exemptions from the obligation where it is being brought pursuant to a bylaw or a rule. Remember that under the proof of vaccination requirements that are imposed by the order, to the extent that those apply to Strata corporations, there are no exemptions, but there are for human rights code reasons, but there will be potentially accommodation requests if it's adopted pursuant to a rule or a bylaw of the Strata Corporation. The second issue is going to be protection of privacy and personal information. And obviously that's been driving a lot of the debate about vaccine passports in the first place, is the privacy implications of collecting that information and then making that information available and using it to gain access to venues, restaurants, theaters, Strata meetings, whatever the case may be. So the September 10th order does contain limitations on the retainer of proof of vaccination information. So if a Strata corporation is involved in a situation where it is collecting proof of vaccination information pursuant to the order, you'll have to look carefully at the order, because it's quite limited what Strata corporations can do, particularly without consent. Beyond just seeing that the person is confirming that they're vaccinated. Even keeping a list of people who are vaccinated can be a challenge under the order. And then the second issue is, even if you're looking at whether you're looking at collecting that information under the order or you're collecting that information pursuant to a bylaw or a rule, the Strata Corporation is going to have to look carefully at the Personal Information Protection Act provisions that govern the collection, use, disclosure, and destruction of personal information. Ideally, the Strata is going to keep as little information as possible with respect to something as sensitive as proof of vaccination requirements. So turning now to Andrea and the topic of employees and vaccinations, I'm going to turn the floor over to her.
Thank you, Allison. I just know that there are quite a few questions coming in.
We'll get to them, Andrea.
Yeah, I was
I'll
just going to
manage them.
say, I was just going to say, we do see them coming in and we will get to them. So from an employment perspective, can the Strata require proof of vaccination? And you're going to love this answer because it's a typical lawyer answer, but of course it depends. So you may, from everything you're hearing in the media, think that mandatory vaccination policies have been given the stamp of approval, and the answer to that is no. One of the reasons for that misconception is because of the federal government's announcement that they are requiring proof of vaccination for all federal government employees. And so there is some misunderstanding out there who is a federal government employee and who isn't. I can tell you that Strata is not. So Trudeau's order in that regard does not apply. We look at the September 10th order that Allison has been talking about, and it does not apply to employers or to employees, even if the employee is working in a place or at an event covered by the order. So our premier was challenged on this question by reporters in that how can you have an environment where everybody is required to be vaccinated except for the people working in there? And the message we received was that order is what the order is, and it applies to who it applies, and it does not intend to cover employers' employees. And the reason for that is that the employment situation is a little bit different than attending a social event, for example. So in determining whether or not you will have a mandatory vaccination policy, there are certain considerations you have to make. And we've already talked about a couple of them, one being human rights laws, one being privacy. So do note that the definition of employee is interpreted very broadly under human rights legislation. There is case law that has said in certain circumstances, more often than not, contractors can be considered to be employees for the purposes of the Human Rights Code. So you have to be quite careful in terms of making sure that you're not mandating vaccinations for contractors, subcontractors who are coming onto site. If they say, you know, I can't get a vaccination because of a disability or religious reasons, you should inquire into that further, and you may have to make accommodation measures. So in addition to disability, there's also the issue of religion. And so we do have some help in this regard. A number of faith leaders have come out and have said that, you know, our religion does not ban vaccinations. The vast majority of religious faith leaders have said that. There are a couple of outliers from the faith-based healing religions, a couple of you know, fairly small membership base who have said we are in opposition to the vaccination. So if one of your employees does come up with a saying, you know, it's against my religion, you are within your right to challenge that and to say, I need a letter from your faith leader saying exactly that it is against the religion. So, you know, if you push back on it, you might find that it's not really religion, it's more creed or personal preference or their interpretation of scripture and tenet that is not necessarily widely adopted by the faith leaders. And the same holds true for disability. We had a question come in, which I answered on the chat, that you definitely can say, I need a doctor's note saying you cannot be vaccinated. And there are many doctors out there who will be kind of hesitant to do that. So by all means, push back on that if somebody says it is a disability. So privacy laws, and Allison touched on this, I won't spend too much time on it, but on first blush, one would look at the situation and say, well, of course we can mandate vaccines among our employees for health and safety reasons. We have an obligation under occupational health and safety regulations to create a healthy and safe work environment. What we do know from the Privacy Commissioner of Canada, that, you know, whatever we do during the pandemic in terms of protocols, privacy has to be considered. And so with that in mind, you have to look at the reasonableness of the situation. So is it reasonable to require an employee to be vaccinated in order to protect health and safety? That would be the question that you would have to answer. Again, on first blush, the answer is yes, but if you were called to produce evidence on this, and you still have all other COVID protocols in place. So for example, your employees are still wearing masks, they're still maintaining 6 feet distances, they're behind plexiglass, they interact with others very little, you might have a hard time proving that going as far as requiring someone to get medical treatment in order to work is not reasonable. And so do remember that requiring vaccinations is basically asking an employee to get a certain medical treatment. And so that's the way the privacy commissioner would look at the situation. We also have employment law. And so it wasn't a term or condition of the employee's employment when they started with you that they would be required to have a vaccination. So if some refuse to, and this is not based on disability or religion, but this is just based on personal preference, you might be faced with a constructive dismissal complaint. And that, sure, go ahead and terminate me, but you don't have cause to terminate me because this was never a term and condition of my employment that I breached. And so you basically owe me notice or severance. So you have to consider, whether or not you're, as a Strata, you're prepared to pay that out. There is potentially the ability to argue frustration. So the employee does not want to get vaccinated and the employer, this is what we need to do to keep our workplace safe. Can you make a frustration argument that the contract has come to an end because of an intervening event, being the pandemic, such that you don't have to owe notice and severance? It's an argument, but we don't know where the courts are going to lie on this. We have had very, very little assistance from the courts in terms of working out any of these issues. We've had a little bit from human rights, and very little from the Privacy Commission. So I wish I could come out and tell you, well, Law ABC was put into place and it says you can mandate vaccines across the board. Unfortunately, we're just not in that situation. So I'll just finish up with a couple of practical issues. So accommodation. So if somebody says I cannot wear a mask or I cannot wear a vaccine and they show proof of it, how are you going to accommodate that? And so you'll have to look at things like PPE, rapid testing. So it's not going to be good enough to say, well, we can't have you here. You are going to have to look at all of the other measures out there that may be available. The other thing to keep in mind, if your employees push back, and we've seen this at the hospital in Windsor, where when the vaccine policy came out, I think 140 to 170 employees said, I'm not getting vaccinated. And so they're all off on a 2-week suspension without pay. What happens after the 2 weeks? So that's the question. We do know that there's a labor shortage right now. So you're going to have to keep in mind, if you mandate vaccines and you have one or more of your employees walk, are you going to be able to replace them? And again, just consider the cost of terminating that. You may have to provide notice or severance. I'm going to say one final thing on privacy. You will be hearing a lot in the media that there are large institutions who are coming out and say, we have a mandatory vaccination policy, and they're so proud of it and they're advertising it. Be really, really careful about that, because essentially what you are communicating is that all of your employees are vaccinated, so that all of your employees have had a certain medical treatment. This is against privacy legislation. And so it may be that one of your employees, their spouse doesn't know they're vaccinated, for whatever reason, they wanted to keep this quiet. And we've seen the government recognize that by allowing minors between the ages of 12 and 19 to get the vaccine without parent permission, knowing that it might cause some friction within the family. So if you advertise this to the world, you're essentially saying what the status of your employees are, and that is their personal information. And that type of disclosure would seem to be unreasonable, because there's really no rational end for announcing that. So with that, I will turn it back over to Allison. We can move on to the next slide.
Thanks, Andrea. So next area that I wanted to talk about today, which is also covered by the health orders, are requirements for for gatherings and events. So the question is, are there any requirements for in-person council and general meetings that are set out in the orders beyond what we've talked about already? So the September 10th order, as I mentioned earlier, imposes requirements on organizers and participants regarding events in a place. And wherever I've put quotation marks, those are all defined terms in the order. And so when you're trying to understand the order, you've always got to go and look at what the defined terms say. So the same definition of place applies with respect to gatherings as it does to proof of vaccination provisions, which is it's a venue other than a private residence, and it includes a conference room, recreation center, workout, gym, exercise, or dance facility or studio. There is, however, a different definition of event, and the definition is in-person gathering in a place with seating. And the order then goes on to distinguish between events that are being held outside and events that are being held inside. So Tony, the next slide, please. So in terms of the restrictions on outside events and inside events, the order contains restrictions that limit the capacity, the seated capacity of the persons attending the event. And the numbers vary depending on whether it's an inside event or an outside event. In both cases, there's a requirement for an organizer of the event and control on access to the event, as well as monitoring during the event. So the access is to ensure that the numbers are not exceeded. The monitoring is, again, to ensure that the numbers aren't exceeded, particularly if you have an event where people may be coming and going from the event. So recall the typical general meeting for strata corporations. We often have people coming and going during the course of the general meeting. We may have people arrive late. We may have people leave. We may have people leave and come back. And so part of the organizer's job is to keep track of who's coming and going, and as well monitoring the actual event itself, including the fact that with inside events, the participants are required to remain seated with some limited exceptions, as noted in the rule in the order itself. For example, going to use the washroom facilities. The event has to have enough seating for each person attending, and that the seating has to be arranged in such a way that all available space is used. So basically, you spread out the seating as much as you possibly can, given the capacity limits of, or given the space that's available and the capacity that is permitted under the particular order, whether it's an inside event or an outside event. With the, as I mentioned earlier, with the inside event, participants are expected to remain seated with limited exceptions, and there are requirements in terms of providing hand sanitation supplies, so our favorite hand sanitizer, as well as toilet facilities. So, so there's a lot to keep in mind in terms of what to do to host an in-person gathering, so an in-person general meeting. As mentioned earlier, Tony is going to be working on checklists that are going to be made available, and it's intended that one of those checklists is going to be assisting strata corporations that do want to hold in-person meetings, given the requirements that are set out in the various orders. So in terms of deciding how to conduct a general meeting, obviously many of the meetings, almost all meetings over the last year or so, year and a half, have been conducted via Zoom or other similar platform. And going forward, we do have some ability to conduct in-person meetings as long as there's compliance with the applicable orders at the time. The way the meeting is going to be conducted is actually a decision for the council to make. It's a majority vote decision of the council. I would hope that when the council is making that decision, especially if there's a decision to conduct an in-person meeting, that the council is going to take into account all the obligations that come with conducting an in-person meeting and the obligation to protect the safety and health of the persons that are attending the meeting. And ideally, there would be a written plan developed, and in some places, in fact, you've got to have a written plan developed, especially if you're conducting the meeting at an outside venue. I note that there are options. I mean, we've mentioned electronic meetings. That's the option. That's the other way that general meetings can be conducted. The CRT has now ruled in a number of decisions that what have been commonly referred to as restricted proxy meetings, which is essentially a meeting that requires attendees to provide proxies to a limited number of people who are going to gather in person, are not permissible under the Strata Property Act. So the alternative to an in-person meeting is an electronic meeting or a hybrid meeting where it's partially electronic and partially in person. Currently, strata corporations can conduct electronic meetings without bylaws until December 31st of this year. After that, the current expectation is that the strata corporations will have adopted bylaws to allow that to continue after that deadline. The advantages of electronic meetings, as challenging as they can be sometimes, is that they do avoid any of the orders that apply, and they avoid the strata corporation's obligations to manage common property with respect to the conduct of in-person gatherings. It also minimizes the risk of persons being ineligible to attend an in-person meeting because, for example, they're not vaccinated. What happens if somebody shows up at the door of the meeting and says, I want to attend, and isn't vaccinated, and then creates problems where the gathering is more than 50 persons? Having an online meeting can avoid some of those potentially not so pleasant interactions. And it also minimizes the human rights code and PIPA considerations that we've already talked about in terms of conducting or any of these requirements that always raise these concerns for strata corporations to have to juggle as part of everything else they're juggling at the same time in terms of COVID. So other areas for strata corporations to think about in terms of COVID and COVID-related restrictions are the recreational facilities and other amenity areas of some stratas. Some stratas don't have any of these areas to take into account, but many do. There is a decision of the CRT that has held that strata corporations cannot indefinitely shut down facilities without a 3/4 vote resolution of the owners under Section 71 of the Act. Last year, obviously, especially in the early days of COVID, when nobody knew what the risk was and how to manage the risk, many strata corporations shut down their amenity facilities. Some have opened them up with some restrictions, but many have continued to keep them closed. That is subject to challenge in the absence of a Section 71 resolution. It is open to strata corporations to adopt bylaws and rules regarding the use, safety, and condition of common property and common assets. So even if a strata is not able to continue to keep the facilities closed because a Section 71 resolution hasn't been obtained from the owners, the strata still has the ability to adopt various restrictions on the use of these facilities to help manage the risk. The first one I'm going to mention is pools. Pools are excluded from the proof of vaccination requirement unless an event is being held, such as, for example, if the strata has a very large pool deck and decides to hold the annual general meeting on the pool deck, and there are going to be more than 50 people in attendance, the way the order is drafted, the proof of vaccination requirements would apply. But otherwise, the pools are not subject to the vaccination requirements, so people just recreationally swimming in the pool, not a requirement. The mask order may apply to the pool deck areas. Go back to our original discussion on the awkward wording of the mask orders in that regard. So that is probably something for councils to consider, whether or not to adopt a rule to make it clear with respect to whether masks apply or not, beyond whatever might be required by the order. And then beyond that, what steps can be taken to manage the risk? Well, obviously, sanitation plans and measures, we've been dealing with those for many, many months in terms of the in-depth cleaning or what's called the deep cleaning that needs to be done with these areas, providing sanitizer and for the users of the facility, and other measures related to that. But beyond that, looking at things like potentially limiting the number of people using the pool, restricting use to persons who are not ill. So stating if you have any symptoms, stay out of the pool or stay out of the pool deck area. And then potentially thinking about whether or not contact tracing might be a good idea. Should the Strata Corporation be keeping track of who's using the pool and when? And again, if you do that, then you've got to think about the personal information aspect of that, because you're now keeping lists of people who are using the pool and when they're using the pool. And that raises its own set of considerations. Turning now to gym facilities, they appear to be subject to the proof of vaccination requirement because of the reference to gathering of participants in inside places for the purposes of adult sports activity or exercise activity or class. And again, as mentioned earlier, there is no minimum number of people in attendance. And it also would appear to apply even if, for example, you have two family members who may have exclusive use of the gym facility under a restriction system where, for example, the Strata Corporation is allowing people to book use of the gym on an exclusive basis. We've now got two people gathered who are related to each other who are now using the gym facility. It appears they have to be vaccinated, which seems a little extreme. Not entirely sure that was intended, but that's certainly how I read the order. The mask order may apply, as I mentioned earlier, given the awkward wording, and it would only apply to visitors. So it wouldn't apply to owners, but it could apply to tenants, occupants, and visitors. So again, the best way to clarify this issue is to adopt a rule. The order does say that anybody who's actively exercising does not have to wear a mask. And again, we look at what other options are available to Strata corporations, or what other measures should Strata corporations take from both a sanitation plan and measures perspective, and then also with respect to what other restrictions should come into play, such as occupancy limits, contact tracing, no use when ill, that kind of thing. And then other amenity facilities. Lots of stratas have theaters, libraries, meeting rooms. The list of amenities is really only limited in some ways by the creativity of the particular developer of the complex. So again, you'll have stratas with sort of more complex facilities are going to have to look carefully at the orders and consider whether any of the orders apply, and if not, what measures should be taken to protect the users of those facilities, regardless of whether they're owners, tenants, occupants, or visitors, as we commonly understand them under the Strata Property Act. What is reasonably prudent given what we know about the risk of transmission in the circumstances? And now I'm going to turn it over to Andrea again to talk about employment situations.
Thanks, Allison. So just a couple of other things on the employment front. You know, even though your employees are using common property, because of that, you might have residents come forward and question whether or not the resident caretaker or others on site have been vaccinated. And so, as we already mentioned, that is personal information, it's private. So you're not really entitled to pass that along. What you can and what you should do is to let residents and other employees know if there's a concern about a certain employee that people believe are not vaccinated, that you are following all their protocols, you're following the public health orders. There is no public health order for employees to be vaccinated, but you are following all of those other protocols and you're reviewing them periodically. So it is important to let those in the strata know that you are on top of it, you are aware of their concerns, and that you're monitoring the situation. It's also important to encourage discussion of those concerns. If individuals come forward, don't swat them away, because you know what will happen then. It will just fester, and then you'll have groups of employees and camps coming forward and saying, this is what we want to see. Another issue that we're seeing quite a bit is bullying and harassment of employees who are believed to not be vaccinated. This can be bullying and harassment by residents, or this can be bullying and harassment by other employees. Remember that you as a strata, as an employer, have an obligation to ensure that there is a non-toxic workplace for your employees, and you do have to address those situations where you have heard or where somebody comes forward making a complaint that they are being harassed because of their perceived vaccination status. That's all I have to say on that, and so I'll turn it over to Allison.
Thanks, Andrea. So there are also, beyond the residents using common areas of the building and employees who are conducting their tasks or their job duties on common property, there will be other people from time to time using common property, and the council is going to have to think about those people and the extent to which any measures, appropriate measures or reasonably prudent measures should be taken to manage that risk. I'm going to say pretty well in most cases that saying no to everything is probably not a good idea. I realize that we're still well into the pandemic, and obviously the numbers in BC have continued to sort of meander along at a level that most people are not happy with, and we still have restrictions on our lives, but we still have to continue living our lives, and people still have to continue living in strata corporations and carrying on the things that they were doing even before the pandemic started. So there are going to be business type activities that are carried out in connection with the common property. There are some strata corporations, for example, that permit Airbnb and short-term use of strata lots. Many don't, but some do. There will be situations in which realtors are coming onto the common property in order to facilitate showings of units, including showings that are being done by open house. There are also some people who are, many of us are still working at home on a regular basis, and if not full-time, and some of those businesses have a client facing aspect to them. By that, I mean there may be clients coming to the unit. So the Strata Council is going to have to take into account, or should be taking into account, what are the activities that are taking place and what are the risks that are really arising from those activities. I mean, the reality is that in most cases, particularly for things like realtors, they are already got their own directions from the real estate councils and boards about how to conduct realtor showings. The Strata Property Act does allow strata corporations to adopt bylaws that place reasonable restrictions on marketing activities with respect to strata lots, but it doesn't allow a strata corporation to completely prohibit them. So for example, the strata can't adopt a bylaw that prohibits open houses or the showing of strata lots. So so the strata will want, the council may want to give some consideration where there is a concern that some of these marketing activities might be being conducted in a way that isn't that may give rise to some risk for residents in the building, as well as visitors to the building. Think about what's appropriate, probably beyond beyond the wearing of masks. And that's likely to be things like restrictions on potentially how many people can use small spaces like elevators, hallways. There might be some desire to limit the number of open houses or the duration of open houses, or how many people could be attending at one time in connection with an open house, so that you don't have too many people coming and going. There's probably, in many stratas, there's also the requirement that the realtor or somebody working for the realtor actually accompanies people to and from the unit in order to minimize somebody wandering off on the common property. And that probably makes a great deal of sense in the context of open houses that are being conducted during the pandemic. So at the end of the day, stratas are going to have to make, I think, some difficult decisions about how to conduct their affairs as the pandemic continues, and as well as information and orders change, because the reality is these orders will not be in place indefinitely. The mask order, I believe, is in place until the end of October. The vaccination order is in place until the end of January. Chances are there may be other orders coming into play. They may be repealed earlier than the current expiration date. So the issue of managing COVID is going to be a live one for strata corporations, I think, for many weeks and likely months to come, given where we are right now. Tony, is there one more slide? And that's it. So I think we've got a whole bunch of questions coming in, and I think Tony's been monitoring them for potentially answering questions. Tony?
Thanks so much, Allison and Andrea. And yes, I've just kind of bulked them all together, and there are a number of the really common concerns that we're getting by email every day as well. So a number of stratas use their underground parking garages for their general meetings. And so the big question is this an indoor or outdoor event? And given the numbers of what we may have attend, that could be more than 50, if and how would this order apply? And of course, it's not just going to be, of course, the underground parking garage, but access to the parking garage, whether people are collectively using elevators and all of the other facilities to get through to them, and are they actually doing seating, etc. So Allison, I think as you've been there as well at the parking garage events, you'd probably be the right person to weigh in on this.
Yes, so the way the order is drafted is it just said the order regarding events, and in connection with, and particularly the distinction between inside events and outside events, seated events, is it just says a place means a venue, which really doesn't tell us very much. It's where an event is happening. And it includes a number of locations, as I mentioned earlier: conference rooms, conference halls, workout gyms. It doesn't specifically mention parkades one way or the other, but I would certainly say, regardless of whether the parkade is inside or outside, or partially inside, partially outside, it fits within the definition of a venue. Beyond that, the order goes on to say that an event inside a tent with one or more sides is an inside event, and an event held in a tent without any sides is an outside event. Most of the parkades, if I'm going to equate it to a tent, and that's all I've got based on this order, most of the parkades I've been to have at least one side and would appear to be caught by the definition of an inside event.
Well, in many parkades, other than their CO2 monitors, don't necessarily have very good air circulation or fresh air as well, right? And that's the other concern, is when you're in enclosed spaces, do you have proper ventilation as the virus is airborne? So, what's the most reasonable and prudent practice? And a large enough parkade that is properly ventilated may be an easier solution for the Strata Corporation, but they still have the obligation to manage the safety of all of those parties who attend.
Yes, exactly. So I mean, at the end of the day, the orders are a place to start, but they are not the last word on how to conduct a meeting during COVID.
Correct. Andrea, this comes up a lot with respect to whether it's a duplex or 400 units, and the general question is about strata corporations. And it's not just the contractor working for the corporation, but maybe contractors working for owners. And can the strata corporation request proof of vaccine of contractors and service providers who are coming on site to do work for the strata corporation or the owners?
That's a good question. And so, the question is the contractor an employee or is the contractor a visitor? And I think in the situation where they come on to do work for a specific owner, I think that they can be considered a visitor. They're definitely not an employee of the Strata. If it is a contractor that regularly comes on site to the Strata, to do a certain service. So they come on 2 or 3 days a week, such as a janitorial service. I think there you're at risk of that being considered to be an employee for certain purposes under legislation. And so you will need to be a bit more careful there of just saying, yes, they are a visitor and we can mandate that they provide proof of vaccination.
So you take that to things like the elevator service company that come in once a month. Are we, they're routine, but they're infrequent, right? But they may also be coming on for emergency calls at the same time.
Yeah, I think in those situations, I think you can be a little bit more aggressive in saying, you know what, we consider you to be a visitor for under this order, and we therefore require proof of vaccination, and if subject to human rights. So I would say that to them, unless you have a reason why you can't provide us with proof of vaccination. So I do believe that is within the Strata's right.
So, and then of course, remembering the consequences of that, we're all suffering the lack of personnel and delays for repairs and contractors. So if you impose those consequences, those circumstances, the consequences may be you can't get contractors for work that you desperately need.
Well, that's exactly right. And so, really what I hope you got from at least my portion of the presentation today is, the factors that you have to weigh and consider as a business, as, a Strata business. And I know that there are a lot of institutions, a lot of organizations out there who say we don't care what the law says, but we don't want to risk COVID breakout in our facility. And so we're willing to take the risk of, legal complaints. So I think that's what every Strata should do, is look at their circumstances and kind of weigh and balance all the considerations to come up with the decision as to whether or not they require proof of vaccination.
At the same time, I think you also, have to consider the risk that's posed. I mean, the reality is if the elevator contractor is coming in once a month to service, who are they really coming into contact with? I live in a building with a high rise. I don't think I've ever seen the elevator contractor, and they're here a lot in my building, unfortunately. So, and I think a lot of residents in the building can say the same thing. So I think you do want to be careful about pushing too much, especially for a lot of the contractors that you rely on to come in and fix things like elevators and HVAC and that kind of thing. It may be a different issue if the contractor is going into individual units and you've got people in the units, and especially people who might be vulnerable in some way, then you might be asking the questions a bit more. But if somebody's going into an empty, well-ventilated unit, what is there really a risk that's arising by an unvaccinated person being in there for a period of time? Especially if they're wearing a mask at the same time. So.
And I think it's important to remember through all of this that up until about 6 months ago, we didn't have the vaccine, and things like mask wearing and telling people to socially distance and to only interact as need be, have proven to be effective. And so, at least from the employment side for the contractor who comes on site, that's the messaging you can give. If we ask that you wear your mask at all times, and we ask that you, avoid interacting with residents to the extent possible. So just remember that we do have all of those other protocols in place that have been proven to be effective.
So we do commit to finishing at 1 o'clock. Alison, one more quick question, and I think that all the Strata corporations will share this in some way or another, but they have an amenity room that's like a social coffee library room. And groups of 10 people want to get together, and they want to be able to play cards, and they want to have coffee and visit, which we're all desperate for, by the way. So I certainly appreciate that. And so the question is can the Strata Corporation permit this, and possibly add a little bit to it? Can they permit it without imposing extreme standards on how this is going to function?
Yeah, I think they can. I mean, as Andrea already alluded to, we have for many months, even before vaccination, we have been able to conduct various kinds of activities safely, as long as you think carefully about the protocols that need to be put in place. So I think the first thing about the room would be, where's it located and what is the ventilation like? And consider how many people can appropriately be in the room from a distancing perspective, potentially, particularly in circumstances where it's somehow a strata sanctioned event as opposed to a owner sanctioned event. I mean, I think if a group of residents want to get together, I think they're going to be more prepared amongst themselves to discuss whether they're vaccinated or not. If they volunteer that information, they're entitled to do that. But I think the strata will want to still impose some kind of restriction saying only so many people can use the room at the same time, and that there may be an expectation that masks are going to be worn. I think the strata will still have to manage that because the activity is happening on common property, and give some consideration to what can be done to protect the users in the circumstances. But as I said earlier, the strata can't ban use of those activities, those rooms in any event right now without a Section 71 resolution. So stratas are going to have to tackle the desire of residents to get together and do things, particularly now that so many people are vaccinated.
Agreed. Thank you. Thank you both so much. We had everyone's emails up there, so if you have questions, just a little reminder to everyone, all of this is time sensitive, where everyone is continuing to learn the process. I'm sure there will be more changes and more orders. Check orders from your local health authorities as well. You may have additional requirements or additional orders from your region and from your health authority. Check those. We will be putting up some checklists. And again, the checklists are in relationship to what are the most reasonable practices for the health and safety of your owners and occupants and how you manage events. And they certainly will help you in preparing how you are managing your meetings. Allison, Andrea, thanks again so much. We appreciate your time, and I suspect we're going to probably be reviewing this again in 60 or 90 days when we see another change in orders or conditions. So stay tuned, and we'll come back to you in a short while.
Thank you.
Thanks, everybody.